Welcome to the meeting of number 85 of the House of Commons Standing Committee on Public Safety and National Security. Today's meeting is taking place in a hybrid format pursuant to the standing orders. Members are attending in person in the room and remotely using Zoom application. I'd like to make a few comments for the benefit of witnesses and members. Please wait until I recognize you by name before speaking. Feedback events can occur. This can be extremely harmful to interpreters and cause serious injuries. The most common cause of sound feedback is an earpiece worn too close to a microphone. We therefore ask all participants to exercise a high degree of caution while handling their earpieces, especially when your microphone or your neighbor's microphone is turned on. A reminder that all comments should be addressed through the chair. Pursuant to Standing Order 1082 and the motion adopted by the committee on Monday, October 23rd, 2023, the committee resumes its study of rights of victims, reclassification, and transfer of federal offenders. I would like to now welcome our witnesses here today. Correctional Service of Canada, Anne Kelly, Commissioner. Kirsten Gagnon, Assistant Commissioner, Communications and Engagement Sector. France Grattan, Assistant Commissioner, Correctional Operations and Programs. Chad Westmacott, Director General, Community Safety, Corrections and Criminal Justice, and Chad's also with the Department of Public Safety and Emergency Preparedness. Sean Tupper, Deputy Minister. Office of Correctional Investigator of Canada, Dr. Ivan Zinger, Correctional Investigator of Canada. Welcome to all of you. You now have up to 5 minutes, or will have up to 5 minutes, will be given for opening remarks, after which we will proceed with rounds of questions. I now invite Ms. Kelly to make her opening statement.
Monsieur le Président, membres du comité.
Good morning, Chair, members of this committee. Thank you for inviting me as a part of your study on the rights of victims of crime and the security classification and transfer of offenders. These issues have received considerable public attention following the transfer of offender Paul Bernardo from a maximum to a medium security institution this past summer. I would like to take the time today to explain more about how security classification and reclassification work and how we uphold victims' rights in the process.
Thoughts are with the victims and their families. What they have gone through is unimaginable. This offender committed horrific crimes, and hearing about this case has brought up strong emotions, and rightly so. I regret any pain and concern this has caused. Public safety and the victim's safety continues to be top of mind for CSC in any decisions we make. Chairs and members of this committee, I have worked with the Correctional Service of Canada for 40 years. I have dedicated my career to serving Canadians and upholding the rule of law. I can attest firsthand that our correctional system works only if we perform our duties according to the law. In Canada, our correctional system is fundamentally based on the rehabilitation of offenders, even if some remain incarcerated for the rest of their lives. This is our legislated mandate. Under the law, CSC must assign a security classification to each inmate and review it at regular intervals. Our approach to both initial security classification and security reclassification is very rigorous. It includes a statistical component using research-based actuarial tools and a clinical component based on the assessment of a set of factors by trained specialized staff. The custody rating scale and the security reclassification scale are both actuarial tools that generate a score based on an inmate's history. This includes, for example, any security-related incidents, previous escapes, and offense severity. The assessment also includes consideration of 3 areas by parole officers: the required degree of supervision and control within the institution, also referred to as institutional adjustment, escape risk, and public safety. These factors are set out in law and policy. The final risk assessment, which combines the actuarial score and the assessment of the 3 areas, determines an inmate's security classification. Once the security classification has been determined, inmates must be placed in an institution that corresponds with their security classification. It is important to stress that at any point, an inmate can be placed or returned to a higher security level if deemed necessary to ensure the safety of the public or an institution. When deciding on which institution is most suitable for the management of an inmate, the law requires that CSC take into account a number of factors, including the availability of appropriate programs and services. Le service a toujours exigé la prise de...
The service has always taken into account victims' rights in making our decisions. At any time during their sentence, the inmate can make a new request with the service. Before any decision is made, the case management system takes into account the entire global situation. We ensure that we communicate the necessary information to victims so that they are heard effectively in the correctional system. On top of this, we ensure that victims are treated with compassion and respect and with equity.
Transfer Paul Bernardo, I heard a wide array of views and felt it was important to order an additional review to make sure that this decision was compliant with the law, policies, and procedures that guide our work. While the review committee concluded that CSC followed all applicable laws and policies, it also recommended that I establish a multidisciplinary working committee to enhance policies and practices pertaining to victims, which I accepted and put in place. The committee is comprised of 11 members, including victims, as well as members of our CSC and Parole Board of Canada Regional Victim Advisory Committee members, corrections expert, and the Federal Ombudsman for Victims of Crime. The Multidisciplinary Committee on Victim Services started its work on November 17th. Over the next months, it will explore how we provide services to victims of crime and examine additional areas that could be further strengthened. We have also recently undertaken a review of our policies to see how we can better serve victims and provide them with more timely information about the offender who harmed them.
Thank you, Ms. Kelly, and thank you for your remarks. Hopefully you'll have some more time to continue through your opening remarks through questions. Mr. Tupper, please.
Thank you, Mr. Chair. I'm happy to be here to say a few words about the work of Public Safety Canada with respect to your study on the rights of victims, crime, reclassification, and transformation of transfer of federal offenders. I'm joined here, as you mentioned previously, by Chad Westmacott, who is our DG for Community Safety Corrections and Criminal Justice. Mr. Chair, from a legislative perspective, Public Safety Canada is responsible for the Corrections and Conditional Release Act. As such, I will be speaking about my department's work in this space, and I will note that we are not involved in the operational decisions of the Correctional Service of Canada, which are under the purview of my colleague here beside me. The Act clearly outlines that decision-making authorities related to operations rest solely with CSC. As you know, that Act guides both the Correctional Service of Canada and the Parole Board in how federal sentences of 2 years or more are carried out. It also provides the foundation for the rights to information protection and participation of victims of federal offenders as set out in the Canadian Victim Bill of Rights. Le Bureau national pour les victimes d'actes criminels.
Public Safety's National Office for Victims is an important resource in terms of the way in which we provide information. It helps victims navigate the federal corrections and conditional release system. For victims, we provide needed information about their rights and the federal services available to them. Input from victims is constantly helping us adjust and refine the information we share. One example would be how we contribute to explaining basic sentence calculation rules for federal offenders. And this includes how the eligibility dates for various types of releases are determined. Since 2015, the National Office for Victims has distributed over 80,000 physical copies of its publications.
The Correctional Service of Canada and the Parole Board of Canada provide registered victims with information about the federal offender who harmed them, and they assist victims in submitting impact statements which can be considered in decision-making and facilitate victim attendance at parole hearings. On July 20th, 2023, a ministerial directive was issued to the service entitled Information Sharing, Security Classification, and Transfer of Offenders. It recognizes that more can be done to ensure victims' rights are considered earlier as part of the decision-making process. This includes implementing a victim-sensitive approach. It seeks to enhance notification to registered victims and to improve how and when it provides notification regarding security classification and transfers. Work is now ongoing across public safety and the CSC to identify the policy and legislative changes to implement the directive. In addition, Mr. Chair, my department supports recent legislative amendments to strengthen the National Sex Offender Registry and empower victims of crime. To ensure victims are aware of their right to information, judges will now be required to ask if victims want to receive ongoing information about their case after sentencing. They will also be required to ensure that their wishes, if known, are entered into the record of proceedings. By receiving victim contact details from the courts, the Correctional Service of Canada will be able to proactively register victims to receive information rather than the onus being placed on the victim. Under the Canadian Victim Bill of Rights, victims can also complain directly to federal departments and agencies if they feel their rights have been denied or infringed upon in order to resolve them in a timely fashion. And if the outcome of a complaint is not satisfactory to the victim, there is an ombudsperson for victims of crime ready to assist. My department also plays a role here in terms of increasing the transparency of the complaint process. The National Office for Victims, in collaboration with portfolio partners, prepares an annual report that compiles standardized information on complaints and how they are resolved. This helps us and our partners monitor new and emerging trends, address any systemic policy issues, and find ways to further reduce the burden of victims. In terms of the implementation of the Canadian Victim Bill of Rights within the federal corrections and conditional release system, the office has held 5 national roundtables so far so that we can all approach this the right way together. Nous avons parlé des responsabilisations de la...
We've talked about accountability, how offenders are reintegrated, restorative justice, as well as outreach and engagement. As a portfolio, we are committed to implementing the Canadian Victims' Bill of Rights. Victims must be treated with compassion and respect. And we remain committed to getting them timely, accurate information in accordance with legislation and policy, the way that they've told us they want to receive it.
Thank you.
Appreciate it. Thank you. Okay, so everybody received a written statement from Dr. Zinger, so we're going to move right in earlier today. We're going to move right into questions, and the first question would be go to Mr. Lloyd. For 6 minutes, please.
Thank you, Mr. Chair. My first question to Dr. Zinger. In June and July of 2022, your office was engaged with Paul Bernardo to ensure that the principles of the least restrictive measures were being respected by Correctional Services Canada. Is that correct?
Yes and no. Thank you for your question. Typically, my office, as you know, we're an independent ombuds office, and we investigate complaints, and we focus on compliance with the law. And typically, when it comes to transfers, the complaints we receive is usually related to a denial, and we investigate to see whether the denial is justified. So in this case, we did have contact with Mr. Bernardo, and it is highlighted in the report of that review committee that was initiated by the commissioner. We weren't asked by Mr. Bernardo to look at his denial for a transfer to an institution in Ontario. He was obviously...
Dr. Zinger, I have limited time, but
Okay.
I will move on. Prior to Bill C-83, under the changes made by the Safe Streets and Communities Act in 2012, the language of least restrictive measures was instead changed to necessary and proportionate. Is that correct?
That is correct.
And in 2012, your predecessor, Howard Sapers, whom you served as a chief of staff, noted his concerns with changing the language from least restrictive measures to necessary and proportionate because he felt that this was ambiguous and would give more discretion to Correctional Services Canada in their decisions, which could include security classifications. Is that correct?
You would have to, I don't recall, you would have to ask him as to, if you ask me.
Well, this was cited in the OCI annual report in 2012 and 2013, where he said, replacing the least restrictive principle with necessary and proportionate measures seems to add an unnecessary layer of ambiguity and discretion where precision and consistency are required. And this language will make it more difficult for my staff to hold CSC accountable for decisions and actions carrying significant life, liberty, and security interests, for example, security classifications. Mr. Zinger, if C-83 had not amended the CCRA to restore the least restrictive measures principle back in 2019, do you believe that Correctional Services Canada would have had more discretion under the CCRA when determining an inmate's classification?
Well, this is hypothetical. I'm not sure if I'm best placed to respond. What I can tell you is that the criteria brought in by the Harper government on that deals with proportionate and necessary is likely to be interpreted as the least restrictive measure, which is consistent with public safety. So I think it's
not necessarily.
It becomes an interpretation,
but not necessarily,
because it is something that the least restrictive is a pillar of principles that Canada and many countries around the world have adopted. It is grounded in international human rights law. It is reflected in, for example, the standard minimum rules for the treatment of prisoners, which were redone in 2015, and Canada endorsed those. It also appears in instruments such as the
Zinger, I know I have very limited time to ask you questions, Dr. Zinger, but when you say it could be interpreted as a least restrictive measure, that does not necessarily mean that it would always be interpreted as a least restrictive measure.
I think this is speculation. I don't know.
Okay. Do you believe, considering the review report that was released by Correctional Services Canada, the term least restrictive measures was cited numerous times in relation to your office's engagement with Mr. Bernardo. Do you believe that the principle of the least restrictive measures, as you understand it, was a contributing factor in his security reclassification?
Well, I think the least restrictive measure is, as I say, a pillar that is not just applied to transfer. It applies to things like searches. It applies to the use of restraints.
Oh, yes or no? Sorry, Dr. Zinger. My apologies, Dr. Zinger. This is a simple yes or no question.
Point of order.
Was the security classification?
Point of order.
I would like to stop my time there, Chair.
When the member, sorry.
Sorry, I have a point of order.
Go ahead.
Mr. Chair, the rules of committee are that the questioner doesn't get to dictate the response by the witness to be yes or no. They have the opportunity to answer the question, and I would encourage all members not to speak over the witnesses while they do. We have interpreters, and we'd all like to hear the answers. And you can, Mr. Chair, I hope that the rules will be enforced that the questioner, the length of time of the question, you have approximately the same amount of time for the witnesses, but that they cannot dictate a yes or no question.
Thank you. Could we all refrain from over talking one another as well as the witnesses and our MPs, please, because it can be a detriment to our interpreters. So if you could continue, Mr. Lloyd, you have 1 minute remaining.
Thank you, Dr. Zinger. My question was clear. In the Bernardo case, was the principle and legal requirement of the least restrictive measures as outlined in the CCRA a contributing factor in determining his security reclassification?
I don't know. And that's a truthful answer because we never we never assessed whether that, we were never asked, there was no complaints, we were never asked to look at whether corrections acted appropriately or not in this case. We never investigated. We never made any recommendation with respect to cascading Mr. Bernardo from a maximum security institution to a medium. So that's my answer.
Do you attribute, I know I've got short time, Millhaven undertook a strategic change to, quote, provide a less restrictive environment for offenders in July of 2022. Do you attribute that change to the integration of Paul Bernardo with the population?
I'm not sure what I understand your question.
Thank you, Mr. Zinger. Now we're moving on to Mr. McKinnon, please, for 6 minutes.
Thank you, Mr. Chair. I think I'll address this question to Commissioner Kelly. I'm not sure if she's the correct person to take it, and you please do fend it off as you need. I think many Canadians are concerned that a transfer of this kind from a maximum to a medium security classification involves some sort of mitigation of sentence for the offender. I wonder if you could talk about that and maybe give us a heads up on the difference in the prison conditions for an offender under the two different classifications.
Thank you for the question. I would say in this case, Paul Bernardo was given the harshest sentence that we have in the criminal justice system, which is a life sentence. He was also designated a dangerous offender. So, and the sentence is the punishment. In terms of the different security classification, at maximum security, you have to be either high institutional adjustment, which means you require a high degree of control and supervision, or you have to be high on escape risk as well as high on public safety. For medium, it's, well, if you go to minimum, you have to be low on institutional adjustment, escape risk, and risk to the safety of the public. And medium is the other types of ratings. Obviously, at medium, maximum and medium have the same perimeter control. And however, in maximum, it's strictly controlled inside as opposed to medium where it's less control, but it continues to be controlled though. So that would be the difference between the levels of security.
So my understanding is that the security classification is really about how the inmate is managed within the system, whether the controls, as you mentioned, placed upon him. It really has nothing to do with the severity or intensity of the punishment that they are undergo.
Well, actually, when we do a security classification, it's, as I said, it's two tools. There's a statistical component and a clinical component. Obviously, we do look at security risks, so we look at offense severity and, previous offenses. We look at those things. In terms of assigning a security classification, that's by law. We have to assign one to each inmate and also do reviews at regular intervals. And for those that are in maximum and medium security, we have to review the security classification every 2 years. And then, however, you can have somebody like Paul Bernardo who remains a high risk to the safety of the public, but we can manage this particular offender or offenders like him in a medium security institution. So it's managing the risk that the offender presents in the institution.
So how does this change life for the offender? I think there's a perception that the lower security classification means that he's out golfing all day. What's the difference in the quality of life for the offender between the medium and maximum security?
Well, first of all, again, at maximum security, it's very strictly guarded. The movement is very, very, very controlled. It's not as easy to do programming, and that's one we're mandated by law to rehabilitate offenders, and that's done through the delivery of services, interventions, and programming. So certainly when an inmate goes to medium security, there's more opportunities, again, for interventions and programming.
Sorry, I was on mute. So how often do these kinds of transfers occur? And, in the event that this particular inmate exhibits some violent behavior, how quickly would it be possible for him to be transferred back to maximum?
So we do many, many, many transfers a year. And inmates do move between maximum, medium, and minimum security. However, and I think that was mentioned by the president of UCOSAC CSN, if an offender exhibit behaviors, we monitor the offender's behavior. And if there's something that the offender is doing, shouldn't be doing, we do not hesitate to return them or to a higher security level. And I think the previous witnesses have talked about the different types of transfers, voluntary, involuntary, and emergency. And we do use emergency transfers in those cases. So the transfer is immediate. Or they are placed in what we call our structured intervention units until we can transfer them.
Yeah. So one of the differences you mentioned was access to programming. So if the
Your time is up, Mr. McKinnon. Your time is up.
Okay, thank you.
If you can keep that for the next round. Thank you, Ms.
Thank
Kelly.
you, Mr. Chair.
Now we're moving on to Mr. Blanchette-Jonca with the block. Thank you.
Thank you, Mr. Chair, and thank you to our witnesses and colleagues who are here with us for this study. Mr. Zinger, first question. I would like to begin to quote something. After a review by CSC, they stated that it was inappropriate to focus on the principle that an inmate be held in an institution that is of lower security rating than their security classification, and that the law should be modified to take into account our most serious offenders, and that the correctional services are limited in the amount of information they can share in order to respect the privacy and confidentiality of inmates. It's important that the government reevaluate the transparency in the correctional services system, and including in parole. In 2018, your office said that CSC was not transparent enough and was not sufficiently held accountable. Does this also apply to the transfer of offenders and their reclassification? Has your office changed its mind on that topic? What I'd say is that what we can see now is that the majority of Canadians agree with the underlying principles of correctional services. The emphasis on rehabilitation, for example, the fact that we send people to jail, this is as punishment, not for punishment. People agree with the idea that inmates keep all their rights except for those that are restricted. And this applies to the majority of inmates. The problem is that when we start to work with more difficult cases, applying these same principles becomes challenging and is a test of our system. You spoke of victims' rights. I think that if there's anything the committee could do, and that all members of this committee could, I hope, have a consensus on, it is taking a look at this notion that being public perception of the coherence between victims' rights and inmates' rights. I do agree with the fact that this is not just a perception, it is a reality as well. And I do believe that the federal government could do much more on this level. And I am definitely ready to give you my opinions on this topic. Great. I'll come back to two very important words. You spoke of perception. We can agree that we're looking here at the information that is shared with the public and this level of trust. So transparency and accountability. Your office brought up these words in 2018, not me. So we're speaking of perception and the information that has been shared on Paul Bernardo's case. What I would like to know is, in your opinion, what was shared by your office in 2018 also concerns the inmate transfers. Has it changed since 2018? And in your opinion, if it hasn't changed, what could be implemented to improve transparency? Well, what's clear is that it is still a problem. In the last 2 months, I've continued to push for Canada's ratification of the optional protocol on the Torture Convention. The goal being that Canada improve its structure to add an external monitoring component to correctional services, but also in any cases of custody throughout Canada. Now, to come back to the question of victims, I don't think it's just a question of perception. The truth is, and I'm aware of this fact, in Canada, inmates' rights seem to offer offenders a lot of recourse, and this is not always the case for victims. I do think that there is a lot of work that remains to be done. We have to take a look at the criminal code. We have to take a look at the court procedures in order to make improvements. For example, there are a lot of so-called victims' rights that are not actually rights because they do not have any recourse for these rights. So they can't be upheld. Also, the Federal Victims Ombudsman is overseen by the Department of Justice. And I think that the Federal Ombudsman should have its own legislation and should be independent and should receive a similar budget to what I receive. Currently, I think the Federal Ombudsman's budget is 1.2, and for me it will be 7.5 million. And so it's difficult to understand.
We'll move on to Ms. Barron, please. 6 minutes.
Thank you, Chair. First of all, I'm here covering for my colleague, MP Peter Julian, and I just want to express my condolences for the families and victims of Paul Bernardo, because I haven't had a chance to do so yet. My first question is to you, Ms. Kelly. In your opening statement, you talked about the importance of victims' rights in making decisions, ensuring communications with victims, taking an approach that's using compassion and respect for victims. Can you please clarify how the process of ensuring victims' rights was how you followed through with victims' rights in making decisions in the transfer of Paul Bernardo from maximum to medium security?
So, as part of the process, the transfer process, we have to take into consideration if victims have submitted victim statements. Those are taken into considerations. In the transfer at hand, we communicated with victims. And there was one victim before we did the review of the case that I spoke with. After the review of the case was done, again, we communicated with victims, and I spoke with many of them to review the findings and recommendations with them. Also, as a result of the review, they made a recommendation, as I said, that we establish a multidisciplinary committee, and we have done so. I mentioned the composition of the committee, and so far there have been 2 meetings, and I think that we're going to listen to the victims, to what they need, and enhance our policies and practices in terms of information sharing.
Thank you. What I'm trying to understand is, were the victims and families specifically of the victims of Paul Bernardo, were they notified of this transfer in a timely manner? What does that look like?
So the way it works for transfers to, let's say, from maximum to medium, in this case, we are mandated to advise the victims. Normally, it's after the transfer occurs. In the case of a transfer to minimum security, we advise the victims prior to the transfer. In this particular case, we advise the victims the morning of the transfer.
Thank you. And how do you feel victims and families of victims finding out after the fact or on the morning of is following what you had identified as ensuring that there's compassion and respect for the families of victims? How does that align?
Again, in this case, we followed the legislation and the policies, but I think there was a recognition that, and that was part of the review, that maybe more could have been done, and that's why we're having the multidisciplinary committee to discuss exactly those things.
Thank you. Can you clarify the transition from maximum to medium security of Paul Bernardo? Does that mean that there's an increased chance now or likelihood that the families of the victims will see him being shifted into medium security, being transferred into the community after that? What does that look like for future steps around supporting the victims of, ensuring justice for the victims who Paul Bernardo so brutally, the violence that he inflicted on them?
Absolutely. He committed absolutely horrific crimes. And the other thing I would say is Paul Bernardo spent 30 consecutive years in maximum security. He was transferred to medium security, and at this point, there's absolutely no talk of certainly going to a lower security level. He just got to medium security, and he remains, and this is, I mentioned this during the press conference, so it's out there that he remains high on the safety, in terms of safety of the public. And no inmate who is high on safety of the public can go to minimum.
Thank you. I wanted to build off that a little bit. We know that in, I'm trying to remember the year, but at William Head there was 2 inmates who were convicted of violent crimes who, of course, escaped from minimum security and then murdered a local man in his home. And I know that this has come up in this committee before. Rightfully so, there's some concerns here around Paul Bernardo being shifted from maximum security to minimum security when we see incidences of people escaping and inflicting further harm.
Point of order,
And I'm wondering,
Mr. Chair.
Thank you.
I'm sorry to cut you off. Was that just a slip up? He was transferred from, correct me if I'm wrong, from maximum to medium, not from maximum to minimum, but you had said minimum twice. I just wanted to make sure that was a mix-up.
That was a miss.
Okay,
thank you very much for clarifying. Yes, I would have been correcting that after the fact, so thank you for clarifying now. I'm just wondering if you can please share with us what you would say to victims of families and communities who are concerned about what this means for moving forward and ensuring justice for these families.
So again, the fact that he's in a medium security, as I mentioned, he in terms of perimeter control, it's the same as maximum security. Again, he spent 30 years in a maximum security prison. He just, not so long ago, got to medium security, so there's more work to do.
Thank you, and thank you, Ms. Barron. Mr. Shipley, please, for 5.
Thank you, Chair, and I'll start with Ms. Kelly. Thank you to all the witnesses, first of all, for being here today. Ms. Kelly, in 2018, the Parole Board of Canada found that Bernardo was at a high risk for violence against a domestic partner, that he is callous, glib, grandiose, cunning, deceptive, manipulative, and a liar. In 2021, the Parole Board of Canada found that Bernardo displays psychopathic traits such as arrogance, entitlement, and lack of empathy, which they found to be not treatable. The Crown psychiatrist for Bernardo's dangerous offender designation found evidence of paraphilia, narcissistic personality disorder, alcohol misuse, and psychopathy. Patrick Lesage, Bernardo's trial judge, stated that Bernardo is a dangerous offender and a sexually sadistic psychopath whose likelihood of being treated is remote in the extreme. Is it your position that this man belongs in medium security prison?
So again, our job is to assign a security classification to each inmate, review it at regular intervals, which we have done in this case. Bernardo came out medium, and then once it's determined, we have to ensure they are transferred to an institution that corresponds to their security level. The fact that he's at medium does not negate the fact that he's also a psychopath and the things that you mentioned. Mr. Bernardo can be managed in a medium security environment.
Mr. Zinger, I'll now turn to you. The CSC review report states that the security reclassification protocol of Bernardo was applied 14 times between 1999 and 2022, always with the recommendation of medium, but was overridden to maximum every time, except this one. What's shocking is that Bernardo was denied a transfer and a reclassification to medium security 4 months before it was finally approved. The report also states that Bernardo suddenly had a change of heart. In fact, the report seems to state that your office's meeting with Bernardo was the catalyst for Bernardo's willingness to integrate. Who from your office met with Bernardo, and what was the nature of that activity?
Thank you for the question. So, as you mentioned, Mr. Bernardo was denied to be reclassified several times, and we never investigated that. And we never made any recommendation with respect to having him transferred to a medium. How it actually happened was primarily we got involved later in the quite late in the process because Correctional Service of Canada did not meet its policy requirement to process a request within a certain time frame, which was 60 days for a request. So we were involved because of that allegation of non-compliance with policy in terms of processing a request. So
Thank you, Mr.
we
Zinger.
met with
I too only have 5 minutes. We've only got about a minute left, so thank you. I apologize for interrupting. Ms. Kelly, just one last quick question back to you. While incarcerated, Bernardo has been an instigator in 9 different incidents, including possession of an unauthorized item and possession of contraband. His parole hearings have also confirmed that he shows no remorse for his crimes. Why didn't his track record behind bars and lack of remorse for his crimes play a larger role in his revised security reclassification?
Again, the security classification is a process. We assess a number of factors. We applied an actuarial tool, and the final assessment is a combination of both. So definitely what you mentioned was taken into consideration, and but the final assessment was that this particular offender could be managed in a medium security institution.
Very quickly, because I have very limited time. You mentioned in your previous discussion that at this point in time, there are no talks to have Bernardo moved from medium to minimum. Is that not a potential now for the future?
I can't speak for the future. What I can say is, like I said, he spent 30 years in maximum. He has been in medium now for about a year, and he's still high risk to the safety of the public. So certainly there's minimum is not on the radar.
Thank you, Ms. Kelly. Mr. Shipley, thank you. Now we'll move on to Ms. O'Connell, please.
Thank you, Chair. Thank you to all the witnesses being here today. Commissioner Kelly, I'm certainly glad that you spoke about the need to do more when it comes to notifying victims. We certainly agree and think that it is completely unacceptable to think that victims, especially in this case, would read about a transfer in the newspaper or in the media. Is something that I hope you and your team are looking at very closely, that it is unacceptable. And I think that this committee would look forward on future recommendations and changes that you will be implementing. I can see the balance between notification of the public at large. We had witnesses from Correctional Services as well as, Correctional Services Union and Parole Board representatives, and they talked about more notification. But I can certainly see the balance of not wanting interference into a transfer and balancing that public notification to avoid any of those types of incidents that is not being talked about here, but I think that's a very real threat. You wouldn't want someone to try and help an inmate escape, for example, during a transfer. And I think that's crucial. But to rely on that and not notify victims' families is not the right balance. And so I appreciate, and I'll leave it there because I think, as you've indicated already, you are working on that. I want to speak about this suggestion that the members opposite have brought up several times about C-83 being the catalyst to allow this to happen. And there was a quote in the Globe and Mail that the original wording around least restrictive was actually introduced by Brian Mulroney in the 90s, and that it changed to necessary, which was outlined by Stephen Harper. But that there is a quote from Public Safety, so maybe Mr. Tupper, you can speak to this, but that there was the suggestion that regardless of less restrictive or necessary, that the process for the custody rating scale in the Bernardo example would not have made any difference in terms of necessary and least restrictive. Are you aware of this quote? It was Magali Dusing. I apologize if I'm getting that name wrong. But can you confirm if you feel that the custody rating scale would have still been implemented the same, whether it was least restrictive or necessary?
I'm not aware of the quote. What I will say is we know that the decisions made by the service are based on evidence. They're grounded in modeling that is reflective of decades of experience in applying these assessments. We know the most effort is placed on those who are at highest risk. And so as we work through those processes, as we look at the evidence-based approach that they take to making these assessments, I'm confident that outcomes are consistent across time.
Thank you. And I have to admit that from the public's perspective, even myself, especially before being in this role, understanding the difference between maximum and medium sounds different. But in terms of that is not an extension of the punishment of the heinous crimes or the crimes in general, that even if there were offenders that, say, had less heinous crimes that were in maximum security, it's really based on the safety and movement of correctional workers inside the facility, of flight risk. What we heard at our last meeting was the difference between maximum and medium, where that in medium it's the same perimeters but not weapons to control within the inside of the facility, and that allows for a little bit more movement in terms of programming. And one of the programming pieces that, again, we don't talk about, and we've heard the heinous nature of Paul Bernardo, but what about ensuring that he understands the consequences of his crimes and his actions, and ensuring that the victims have that approach to ensure that he doesn't get to live without understanding of the damage that he did to victims and to, frankly, women across this country.
Thank you, Ms. O'Connell. Mr. Tupper, that's your time. So
Sorry.
That's all right. We'll move on to Mr. Blanchet-Jonca, please.
Monsieur le Président,
Thank you, Mr. Chair. I will continue questions for the Commissioner of CSC, Ms. Kelly. The former Minister of Public Safety, Marco Mendicino, said that the Canadian population deserves to know why an offender was transferred from a maximum security to a medium security prison. The system should have done more. We need to do more so that victims be at the forefront of these decisions. I'm determined to ensure that this happens. That was mentioned in a communication recently. CSC has a protocol to follow and has to respect victims and inmates' rights. What's your comment on what was said here? I think that in this specific case that we're speaking of, and this is why we established a multidisciplinary committee to see what more we can do for victims, what more information we can share with them when we do share it. And the review of this case that was done said that there is work to do on this level. Okay? Currently, we're aware that the right to privacy supersedes the rights of victims to have access to this information. You spoke of a committee that was established. What more could we do to ensure that families have access to information? Well, in the department's directive, first of all, when they're considering a transfer, they need to interact with the victims to make sure that they are aware and that they can update their declaration. And we need to look at which information we're sharing with them, because they can always update their declaration. My colleague has something to add, I think. I'd just like to clarify that in this case, we did notify victims before the transfer was done, even if it wasn't a long time before. But the media didn't pick that up right away. They did appreciate having this information ahead of time. Concerning the department's directives, this is something that we established to give more information to victims, yes, but also to allow them to give us, to get more information on their safety, for example, any geographic aspects of the transfer.
Merci beaucoup. Thank you, Chair. I'll continue on my questions to you, Ms. Kelly. My first question is it true, Mr. Wilkins, who was here prior to me being here, who of course is the president of Union of Canadian Correctional Officers, said in his testimony last week that correctional officers are often not being engaged with case management teams in making decisions around transfer of inmates. Is this true? Can you comment on this?
So the case management team consists of the parole officer and other members, including correctional officers. So correctional officers are assigned a small caseload, and France could speak more to this, but every 45 days they have to do a structured casework record, and it's a bit of a template. They note whether the offender was involved in any incident, whether the offender works, any programs, so it's quite detailed. Also, every day they submit observation reports, and those observation reports and structured intervention records are actually information that is taken into consideration by the parole officer, who is the person that actually makes recommendations. So they are definitely part.
Could you explain why the concerns would be there then, that they're not being engaged to the level that if a union president is bringing forward these concerns, can you explain what that might be based on?
Well, actually, I was very, very pleased to hear Mr. Wilkins say that correctional officers would want to be even more involved in the case management process. And I can tell you that this is something that I'll be discussing with Mr. Wilkins.
Thank you. I forgot to set my timer, so I'm going to keep asking questions till I get cut off. There we go. Ms. Kelly, can you tell us about the process of information sharing between the institutions that Paul Bernardo was transferred between and amongst the correctional officers in both institutions? What does that communication process look like between the two?
Well, when we transfer an offender, normally there's information shared between the parole officers from one institution to the other, so they know who they are getting at the other end. So that's the way it works.
Thank you, Ms. Barron. Okay, now we'll move on to Ms. Thomas, please.
Sorry, thank you. Thank you very much. Ms. Kelly, I'm just wondering a couple of questions with regards to the timeline. Can you just confirm to us on what date the transfer took place with Paul Bernardo from maximum to medium security?
The transfer took place on May 29th.
Thank you. And can you tell me what date the minister was made aware that this transfer would be done?
Let me see. So there were notification. I think this is something that was also mentioned in the press conference beginning in February, then again in March and in May.
Okay. And then can you tell me on what date the victims' families were made aware of this transfer?
The victims' families were made aware of the transfer the day of the transfer, the morning.
Okay. And was that notification given before Mr. Bernardo was transferred or after?
It was by phone and in writing, and then afterwards, some of them we recontacted and spoke with to give more rationale around the decision making.
Had the transfer already taken place?
Not the morning of, no.
Okay. It's interesting to me that the victims' families were not told until essentially the moment of Mr. Bernardo's transfer. As a system, in your opening remarks, Ms. Kelly, you said that victims need to come first, that they would be the priority. But it seems that Bernardo actually knew of his transfer before the victims' families did, which would then be putting him as the criminal ahead of the victims. Is that not true?
Well, again, in terms of offenders, they can request a transfer, and then or we have to do the security classification at intervals, and sometimes that will lead to a transfer. So we work with the offender. In terms of the victims, again, we followed what was in the law and the policy. So because he was transferred to a medium security institution, as Kirsten said, we informed the victims the morning of the transfer. But moving forward, this is, again, a recommendation that was made, and this is why I established a multidisciplinary committee so we can work with the victims to see how we can improve our services.
Sure. I think my point still remains. Mr. Bernardo was afforded the opportunity to know that he was going to be transferred before the families themselves, the families of the victims, were made aware of such a thing, which again, I think highlights the fact that actually the perpetrator was put before the victims' families, the victims essentially. And so I just think it highlights something that is very wrong with our justice system. And when we're talking about the re-victimization of those that are impacted by scenarios like this, we have example after example. I can think of Terry Lynn McClintock, who, of course, brutally assaulted, raped and murdered an 8-year-old girl and was moved from prison to a healing lodge. And only after that was the family all of a sudden notified. And the father spoke of the traumatic impact that that had on him. I think about Nicholas Beige. In 2017, he was in Pickering, Ontario, Miss O'Connell's riding, and he murdered his wife. She was 9 months pregnant. He stabbed her 17 times, and he was moved from maximum to medium security. And it was only after that the family was made aware of this. And the mother has spoken out about this and the re-victimization of that and the impact that it has had on her as an individual. I think about Mark Smith. He brutally killed 2 people for no other reason than simply being fascinated by death. And he was convicted to serve 2 life sentences. And he too was moved from maximum to medium, and then families found out only after. And they have spoken out about the impact of that re-victimization. And so I would have to ask you, Ms. Kelly, do you truly believe that victims are put first?
It's a delicate balance. I can understand. I actually, like I said, what you mentioned, some of the crimes that were committed, it's unspeakable, unimaginable. And frankly, I don't know what they go through. I can only imagine. The thing is...
We're at time. My question is simple. Do you believe that the rights of victims are put first?
Again, it's a balance.
The question's simple. Do you believe that the rights of the
Ms.
victims
Kelly,
are put
thank
first?
you, Ms. Thomas. We're going to move on to Mr. Biddle now, please. Online.
Thank you so much. I'd like to ask my first question to Mr. Tupper. You stated that public safety is not involved in the operational decisions of the Correctional Service of Canada. Can you explain why that is?
Within the context of how our portfolio works, my relationship with all of the portfolios would be driven by policy, by our ability to convene and provide oversight within the portfolio. Operational matters in all of our organizations are vested in the leadership of the respective organizations. And that has to do with the expertise of the organizations and their capacity to best make those decisions.
Thank you so much. There's been some suggestion that and maybe more so in the past when this first came up, that the minister could merely make an order pursuant to standing legislation specifically related to one specific offender. Is that something within the minister's powers under the legislation?
The specifics of the powers, Chad, why don't you drop in?
Thank you. Thank you very much. There is definitely a separation. We'll have to take a look at the specifics in the legislation, but there is definitely a separation in terms of the ministerial decision-making and the operational nature of CSE. And it comes down to the legislation sets the parameters under which CSE operates and the authorities of the minister. But in the case of a transfer of an offender, it definitely comes down to the legislation setting the parameters that Commissioner Kelly has referred to. But then the operationalization of those parameters fall under the CSE's mandate.
I guess I'll be even more blunt. Would it be a legal order for the minister to interject in the specific transfer of an individual? And maybe that's a better question for Ms. Kelly.
Well, my understanding is the minister does not have a role. It's very much an operational decision.
Thank you so much. If I can turn to Dr. Zinger. Later this week, the House will debate Bill C-351, which requires inmates who've been found to be a dangerous offender to be designated to a maximum security penitentiary. If passed, what impact would this bill have on public safety, if any?
I'm not sure. Again, I'm not sure. I'm not familiar with that. What I can tell you is that for those who are designated dangerous offenders and received an indeterminate sentence, not a determinate followed by a long-term supervision order, for those who are designated dangerous offender, indeterminate, the vast and great majority of them will never get out of the penitentiary, and most of the great majority will die behind bars, to a point where we could actually suggest that a dangerous offender designation with an indeterminate sentence is actually a life sentence without parole for the majority of them.
And then I guess on the topic of Bill C-351 to Ms. Kelly with the potential requirement of maximum security, would that impact safety within an institution?
I would say yes. First of all, probably we might need more space at maximum security. And also, at this point, there's no incentive for offenders to participate in rehabilitation program in terms of maintaining good behavior. Because the fact is that, we have security classification, we have processes, but there are inmates that will never make their way to minimum security. So I just want to be clear on that. But definitely keeping those that are serving life in a maximum security for the rest of their life would actually have impacts. And impacts in terms of how we manage the population and potential impacts on the safety of our staff.
Thank you, Ms. Kelly. Thank you, Mr. Biddle. We're moving now to Mr. Baldinelli, please.
Thank you, Chair, and thank you to the witnesses for being here. I think all of us can fully sympathize with the victims and their loved ones, and I think that's why we're all here today, to try and make some sense of the decisions which were made that allowed an individual as heinous as Paul Bernardo to be transferred to a medium security institution. Ms. Kelly, I just want to begin. On July 20th, which was the same date that you and Correctional Services of Canada published its review into the transfer of Paul Bernardo, the Canadian press quoted you as saying, and I quote, "The fact that he, Paul Bernardo, was at a medium security institution does not negate the fact that he is a psychopath and that he committed horrific and unspeakable crimes," end quote. So how is it then that you can still call Paul Bernardo a psychopath on that day, and you repeated that today, and still feel comfortable with your decision?
Again, because when we look at the security classification and we do the process, you can have inmates that may lack remorse or psychopath, but we can still manage their behavior in a medium security environment. I think it's important to remember that in maximum security environment, over 95% of the inmates that are there because of their behavior. They're assaultive, they're harming other inmates, they're assaulting staff. That's not the case with this particular offender. He can actually be managed in a medium security environment.
Ms. Kelly, let me just build on that then, if you think he can be rehabilitated in some sense or taken care of. I'm in receipt of an email that was written to you on June 8th from my constituent, Marcia Penner, who was writing to you to indicate her clear opposition to the decision made by CSE. Marcia is one of the best friends of Christian French, who was raped and murdered by Bernardo. In her letter, she's quoted as saying, "This man is a monster and one that is beyond rehabilitation. He is a serial pedophile rapist, abductor, and murderer. He has been deemed a dangerous offender, the worst of the worst. If he doesn't fit the mandatory requirements for maximum security for his entire prison stay, then please tell me who does." In your email response, you provided a link to the statement you issued on this on June 5th. However, what I find more interesting is your boilerplate contact information, which contains this quote: "Every job is a self-portrait of the person who does it. Autograph your work with excellence." I would seriously question if this transfer decision was excellent. My question to you then, if not Paul Bernardo, then which dangerous offender, rapist, serial killer needs to be in a maximum security institution? If not Paul Bernardo, the worst of the worst, then who?
So again, in maximum security institution, according to the legislation and the regulations, are those who are high institutional adjustment, so require a high degree of control and supervision, or are a high escape risk and high public safety risk in the event of an escape. Those are the offenders that are actually meet the criteria for maximum security.
Ms. Kelly, this is the worst of the worst offenders in Canada. A self-admitted psychopath. You've admitted that here again today. Do you not realize when you make comments like that, the impact it has on the families and on the friends and to the general public? I mean, it almost brings the justice and correctional system into disrepute because they begin to question, who is your client? Is your client Paul Bernardo, or is it the Canadian public? So can you answer that for me? Who is your client?
So as the commissioner, obviously, I take my job seriously. That quote that you mentioned is one that is in my signature block that I've used for over 30 years. I believe in that. What I would say is that as commissioner, I want to ensure that the public, staff are obviously safe. And that's doing our job. And I can understand, again, this particular transfer evokes strong emotions, and rightly so. And the thing is, though, the institutions, is an offender manageable within a certain institution? And both maximum and medium security institution have the same perimeter control.
Then why make the change? Why could not Paul Bernardo, who's committed the most heinous of crimes, stay in maximum security?
Because when we reviewed his security classification, for many years he was in maximum security because he required a high degree of supervision because he couldn't integrate with other inmates.
That changed in 4 months.
Thank you, Ms. Kelly. Mr. Baldinelli, thank you. We're moving on now to Mr. Gahir, please. Online.
Yep. Great. Thank you, Chair. And thank you to all the witnesses for making time and appearing before the committee. My questions are for the Commissioner, Commissioner Kelly. I wanted to talk about the custody rating scale, actually. At our last meeting, I cited a 2022 Attorney General report that focused on systemic barriers in corrections. In that report, the AG actually noted that for each offender admitted into custody, correction staff are to assess the custody rating scale's results to determine an offender's security level. And they found that the correction staff had overwritten the results recommended by that scale for 30% of all security assessments, with almost half moved to a higher level of security. I wanted to ask, why would there be manual overrides in 30% of cases?
So again, the custody rating scale and the security reclassification scale are tools that assess certain measures. So they assess institutional adjustment and security risk. But then a parole officer who has specialized training must assess the 3 areas: institutional adjustment, escape risk, and public safety. So it is possible. The actuarial tools give you a score, but then based on an appraisal of factors, which combines the actuarial tool and this assessment, it determines the security classification of the inmate. So it does happen that the final offender security level is different from. Oh.
Guys, can we just keep the noise down a little bit while we're answering and asking questions? Thank you, Ms. Kelly. Continue.
Sorry, is different from the score generated by the actuarial tool. And there are very valid reasons for that.
Great. We know that an offender's custody rating can change over the period of their incarceration. For example, if an offender is in a medium security facility and they commit a violent act, or they're involved in smuggling contraband, for example, they can always have their security reclassification raised back to a maximum, correct? Sorry, you cut out. Could you repeat that?
Pardon me?
Sorry, it cut out. I think you said correct?
Oh, yes, I'm saying yes. So their behavior is monitored, and at any level, if so at medium and minimum security, if an offender is, for example, we find out involved in trafficking, yes, they can be sent back to a higher level of security, and they are.
Great. So I wanted to talk about the independence of correctional services. Could you comment on the importance of the operational independence for Correctional Service of Canada?
Well, I would say that, again, we are trained to do this work. We have professionals, and again, we have the authority is delegated to CSC through legislation, and again, we have tools, we have procedures, and we have practices. And we have certainly the expertise, and I'm very confident in the ability of our CSC employees to make informed assessments and decisions.
And my final question, who do you think is best placed to make the decisions on the security classification of offenders? Is it correctional professionals who work collectively as part of an individual's case management team, or do you think it's politicians sitting in Ottawa?
It should be correctional professionals.
Great. Thank you.
Thank you, Ms. Gahir. Thank you, Ms. Kelly. We are now moving on to Mr. Blanchet-Jonca, please.
Merci, Monsieur le Président.
Thank you, Mr. Chair. I'm going to be continuing questions with Ms. Kelly. I would like to hear you speak of, once again, the importance of maintaining this security clearance as an independent process, independent from any politics. Once again, I would say that, firstly, in the law, it's clear. We need to assign a security clearance to each offender and review it on a regular basis. And this is what we do. And then based upon this security clearance, we need to transfer the offender to an institution that corresponds to their security clearance. Thank you. Could you specify the importance of this being independent and apolitical, especially the lack of politics? Well, once again, what I would say is that our duty is to respect the law that is in place. Our staff is trained to do this job, and the law applies to every inmate. Would you agree with me that it is not politicians that should be managing prisons? No, it is our operational staff. I'd also like to hear you talk about Bill C-351, tabled by the Conservatives, that will be debated in the House tomorrow. It aims to remove the Correctional Services agents' discretion to modify the security clearance of dangerous offenders, including those who have been found guilty to first-degree murder. Could you speak to this, please?
C'est clair que ça aurait un impact.
What's clear is that this will have an impact on institutions. There would be no reason for inmates to have good behavior or for them to participate in different programs. I think that this could put at risk the safety of our staff and, at the end of the day, of Canadians' safety as well. In terms of victims' rights, I'd say that they would be there their whole life. So thank you, Ms. Kelly.
To Ms. Barron for 2.5 minutes, please.
Thank you, Chair. I'm wondering if you can help me to understand. So there's been many discussions about, so far in this meeting, about Paul Bernardo having been in maximum security for 30 years. You discussed the factors that are considered in that transfer from maximum to medium, including institutional adjustment, the risk that he could escape, and the risk to the public if he did escape. Now, the rationale that I've heard so far is around the fact that he has apparently shown some signs of institutional adjustment. But is it not a combination of factors that is looked at? Why would one factor supersede the remainder, including the known risks if he were to escape, the risk to others in medium security alongside him? It seems like there may be attention being paid to one factor over the others. Can you speak to that?
No, actually, all three have to be considered. It's an assessment, and it's in the regulations that we have to assess the three areas: institutional adjustment, escape risk, and risk to the safety of the public.
Okay, so quickly, maybe if I could, just to clarify, because somebody who's on the outside, I'm not in the inside of this. We hear reports that there was a psychologist report that concluded that Paul Bernardo participated in offense-related programming but continues to exhibit offense-related problematic attitudes and behaviors, that he's had several responsivity issues and warned that improvements remained intermittent. I don't know about you, but I have serious concerns when I see reports that Paul Bernardo has been displaying the same behaviors as he had previously had, that his remorse is not there, and that he has a high risk of I can't think of the word right now, but of doing the same sort of things he had done before. And so I'm just worried, how is it possible that he has been moved from maximum to medium under the circumstances of the information that we have provided that's publicly available of the concerns surrounding this particular person?
So in the regulations it actually specify what you have to be classified as maximum, medium, and minimum. So maximum, you have to be high on institutional adjustment or high on escape risk and risk to the safety of the public. It has to be both.
Time's up. Thank you.
Okay.
Thank you. And we'll move on to Mr. Shipley now for 5 minutes.
Thank you, Chair. There's been a few questions today about the differences between maximum security prison and medium security prison. Earlier today, Ms. Kelly, you mentioned, and I wrote it down specifically, so I will quote you, that you said there's more opportunities for offenders in medium. I make no apology for my next statement. I expect and want Paul Bernardo to have zero opportunities. You also mentioned that he was incarcerated in maximum penitentiary for 30 years, and he was integrated, which was part of the reason why he led to his getting classified to medium. He was only integrated for 4 months. How could there possibly be such a change of heart in just 4 months of integration after 30 years in maximum?
So yes, he was 30 years in maximum, but when we say that July 2022, he was fully integrated, but in the report you will see that this inmate's integration was part of a longer-term strategy that involved many steps over several years. So he started integrating with smaller groups at a time, and then in July 2022, and he was monitored throughout that time. In July 2022, he was fully integrated, and that is the reason at that point that months later his security classification was reviewed, and he was classified medium.
Thank you for that answer. And you mentioned that he was monitored during that time. I hope this horrendous criminal has been monitored for his entire 30 years. Ms. Kelly, in our last meeting, Jeff Wilkins, the head of the Corrections Union, raised serious concerns about the routine overriding and downgrading of security classifications by Upper Management and Corrections Canada. He stated that he has no issue when a security classification is upgraded, but that when it's downgraded, it can lead to serious public safety concerns. We heard that this practice contributed to 2 inmates escaping and brutally murdering a 60-year-old man in British Columbia. How many offenders' security classifications were overridden to a lower security classification last year? That's my next question.
So there are more overrides to medium than to minimum. Override rates, so minimum is around 9%. But actually, we did some research. So the custody rating.
My question is not about your research. My question is about how many offenders' security classifications were overridden to a lower security classification last year. Do you have that information today?
No, I don't.
Okay, will you commit to this committee that you'll be able to provide that?
Yes.
Table that over the next little bit? Thank you for that. That'd be very interesting information to receive. Ms. Kelly, your department emailed the minister's office multiple times about the Bernardo transfer. Given that you followed the process put in place for you by the Minister of Public Safety, did you have any reason to believe that the minister was unaware of the transfer?
Well, for us, we followed a long-standing process. We notified, and I'm not in the minister's office. So, like I said, we followed a long-standing process.
Well, in that process, but it was long-standing, and I'm sure you have many chats with the minister and his staff over that period. Did you not find it odd that Minister Menachino did not bring up the transfer at all between February 27th, when the Assistant Commissioner gave the heads up to the minister's office, and May 29th, when the transfer occurred? That's almost 3 months.
Well, first of all, I have to go back to see if I had any meetings. And normally, if we do have meetings, it's on very specific topics. So
I would think, just if you're having any discussions with the minister or his staff, this was a very high profile, and the minister stated at the day of the transfer that he was shocked and dismayed that this had taken place. So I'm surprised that there was no discussions, or obviously that you weren't surprised that nothing was being brought up to you. This was probably one of the most high profile transfers. I know you mentioned 41 years, a long career, and thank you for that. But this must be one of the largest high profile transfers ever to take place, and there was no direct discussions between you and the minister regarding this. Is that correct?
Again, we followed the long-standing process, but afterwards the former minister said, I want to be directly and formally advised, and we put in place a process to do so.
Thank you, Ms. Kelly, and thank you, Mr. Shipley. We will now move on to Mr. McKinnon for 5 minutes, please.
Thank you, Mr. Chair. I was about to ask you, Commissioner Kelly, earlier about program access and their medium security. Why is that important for the administration of the prisoner?
Because our programs are world-renowned, they're research-based, and they do reduce recidivism. Doesn't mean that, again, it works in the same way for every offenders, but for us, and I think the president of UCOSAC-CSN said that, we don't want Heidelands. So we want offenders to be participating in either education, in programs, in employment, in constructive leisure. It's very important for the management of the institution. But programs, as I said, research has shown that they reduce recidivism.
I think reducing recidivism is important, but I think none of us expect, and certainly all of us hope, that he never sees the light of day. So it seems to me recidivism is not our major concern here. Does access to programs, better programs, can be that seen as a benefit to the inmate, or is that really the value is in terms of helping them to be managed within the prison environment?
It's to be managed. In programs, you learn many things. So even for those that may never be released from an institution, they still learn valuable skills in programs, and actually you see it in their behavior in the institution. So it certainly helps to, again, protect staff, ensure the safety of staff, and the other inmates as well.
Thank you. I noticed a common thread in questions from my Conservative colleagues. There seems to be still an impression that somehow the reclassification of Mr. Bernardo to medium security is some sort of a mitigation of his sentence. Can you tell me, are the pillows softer in medium security?
No, they are not.
So the conditions of his imprisonment, basically, he was not sentenced to maximum security. He was sentenced to serve a term of some number of years, or whether in a prison. He wasn't sentenced to medium versus maximum. So the change of classification is really only about managing the prisoner, managing the conditions of the prison, and determine whether or not this person is a danger within the institution, but it does not in any way increase their opportunity to be put on the street or to escape.
That's right. It's truly about security classification is very, very important, and again, it's to manage the inmates where they should be managed.
Okay. So the day-to-day experience of Mr. Bernardo in medium security is, except for the increased access to programs, is essentially the same as it would be under maximum security.
Yes, he gets up. It's the same food. It's the same type of cell. It's the same bedding. So many of the same things that you would have at maximum security are there in medium security.
So he's not getting any kind of a free ride here. He's still enduring the full import of his sentence. With the benefit to society is perhaps it is less expensive to manage him in a medium security environment.
It is.
If you have any further comments on the nature of his experience and whether you've indicated he's not likely ever to see.
Thank you, Mr. McKinnon.
Security.
Thank you.
Thank
Ms.
you.
Kelly. We're moving into the fourth round now, and first up is Mr. Lloyd for 5 minutes, please.
Thank you, Mr. Chair. Commissioner Kelly, thank you for coming here today. Would you say that the law was followed in the transfer of Paul Bernardo?
Yes.
And would that law include the principle of least restrictive measures?
I just want to say least restrictive measures consistent with the protection of the public.
Of course.
Yes.
But that is part of the law, is that not true?
Yes.
There's been a lot of debate about this least restrictive measure, so I'm hoping that you can provide this committee with some information. I'd like a detailed number of the total amount of inmates that were transferred from maximum security to minimum security since January 1st of 2012 to the present day. I'm not asking for it now, but if you could provide that. Agreed?
Okay.
Secondly, can you provide a justification for the transfer of each of those inmates? No personal information, but just a general justification for the reasons for those transfers during that same time period?
We can tell you the type. So we'll see what we can do.
Okay, well, and also, given that this is somewhat of an unprecedented transfer and the only precedents that we can find for a transfer of this magnitude is the Terry Lynn McClintock transfer that happened prior to C-83 becoming law, protecting all personal information that is redacted, and given the precedent that you have released the review into Paul Bernardo's transfer, will you commit to providing the review of Terry Lynn McClintock's transfer information?
Okay, I'm making a note of that as well.
Okay, well, I'd like to get a commitment that barring any concerns about personal information, which, I mean, you have redacted in the Bernardo case,
Okay.
at the same precedent, can you commit to providing this committee with the review of Terry Lynn McClintock?
Yes.
Thank you. Going into my final round here, I note on Roman numeral 4 of the review report into the Bernardo transfer in paragraph 4, it outlines that after his June 2022 rejection, he applied in July 2022 after he had integrated into his unit. Now, at that time, it says information provided to the review committee indicated that after the offender had applied for a transfer, blank, redacted, the Office of the Correctional Investigator initiated informal discussions concerning his security classification to ensure compliance with the, quote, least restrictive measures principle and legal requirements as per the CCRA. What is your understanding of the Office of the Correctional Investigator's intervention in regards to the security reclassification of Paul Bernardo and his rights under the principles of the least restrictive measures?
Well, I can speak. I cannot. Oh, Ivan is gone. Okay, I can't speak to that because that would have been done at the. It would have been at the local level. That discussion.
The review report indicated that the OCI had concerns about the whether or not his security classification was appropriate, and he was here earlier, and he suggested that he was concerned about the timeline, that he wanted it done in 60 days. He was concerned corrections wasn't getting it done on the timeline, but it said that he initiated informal discussions. I want to know what those informal discussions were regarding Correctional Services Canada's compliance with the least restrictive measures principle and legal requirements. What were those discussions?
I can't speak to them.
Okay. Yes. And a moment here. And I would also like to just confirm, as per my previous request, could those be deposited for the January 15th with the clerk? Is that enough time for you to deposit those previous commitments?
The reports you requested?
Yes.
January 15th?
Yes.
Yes.
Thank you. Now, it seems to me that the Office of the Correctional Investigator got involved in July of 2022, but it said that the report said that there was a previous ongoing investigation by the Office of the Correctional Investigator. What was the nature of that investigation in relation to Paul Bernardo?
I don't know.
Did the Office of the Correctional Investigator make known to you that they were doing an investigation? Did they make inquiries on regarded to Paul Bernardo's security classification process?
Not to my office.
Can you commit that your office, barring any sort of confidentiality requirements, will share that information with this committee to determine, what was the nature of these investigations? What were the Office of the Correctional Investigator's concerns in launching this investigation?
Whether we received any correspondence?
Yes.
If we, like I said, I don't know
If
of
you
any,
haven't.
but okay.
Thank you.
Lloyd, thank you, Ms. Kelly. We are now moving on to Mr. Scheifke.
Thank you very much, Chair, and I want to thank our witnesses for being here today and also add my thoughts to the families of the victims of Mr. Bernardo. My first question, and I'm going to dedicate most of my questions to you, Ms. Kelly, is with regards to maximum penalty under Canadian law. That was applied to Mr. Bernardo, correct?
Yes.
And since he's been incarcerated, he has been for the last 30 years in maximum security, correct?
30 consecutive years.
30 consecutive years, okay. You had mentioned in your opening remarks, you commented on actuarial tools and actuarial scale that you use in determining whether or not an inmate is transferred. Can you give me 3 factors out of all the factors that you use in determining whether or not one should be transferred from maximum to medium security?
So first of all, it's very important to say that the actuarial tools, they help anchor the clinical judgment of the parole officer. So it's really a tool to assist. But we look at institutional adjustment, so any incidents, escape history, street stability, alcohol, drug use, age at time of sentencing, number of prior convictions, severity of current offense, sentence length, breaches of conditions.
So, Ms. Kelly, all of that
Yes.
was used in determining that Mr. Bernardo should be transferred from maximum to medium, correct?
Yes.
Would there be any points attributed to how much media coverage any particular inmate received in your determination? Is that part of the discussion?
No.
Would there be any points awarded one way or the other as to how much we as elected representative wanted to see an inmate housed, where we would want to see that person housed?
No.
Would there be any points put forward either way as to the strong will of any minister of any political party? Would that play a factor in where, or your consideration of whether or not an inmate should be transferred?
No, because we are guided by legislation and the regulations and by policies.
And correct me if I'm wrong, but top priority for you and all of the workers of the correctional facilities in Canada is to keep Canadians safe. That is the basis for
Absolutely.
your decisions. Okay.
Absolutely.
And so far, you've done, and I will credit you and your team for this, we've seen the rates go down significantly in terms of inmates that have escaped. We reached a high of 2006, 2007 of 38 inmates that escaped. We went down to a low, a 20-year low of 9 in 2016, 2017. And then we've seen 2018, 2019, 13, 2019, 2020, 12, 2020, 2021, 11. We're going steadily down, right? And that
Yes.
is the result of the good work that you and your team are doing.
Thank
and I want
you.
to congratulate you on that. What I want to use my time here for, and this is the message that I would like to convey to you and your team, which I've said have done good work in keeping Canadians safe, is that I think that there was something that was done, unfortunately, incorrectly here. And I hope that this is the focus of your work and your team's work with the multidisciplinary committee. And that is the way that the victims, the families' victims were treated here. The fact that they were told the morning of the transfer, without given any kind of necessary counseling, possibly after hearing this news, watching it on the media, the way that must have impacted them. And I say this as a father, as a brother, as a son, as a member of parliament representing my community, Vaudreuil-Soulanges. I cannot imagine what kind of an impact that must have been and what kind of a day they had. So there was an oversight here. I'm glad that you acknowledge that. And I truly hope, and I'm passing this message along to you, that I truly hope that will be the focus of the work that this committee does, and that there's due diligence put in place to ensure that the victims, the family's victims, are treated with greater due diligence and greater care moving forward. And that's how I want to use my line of questioning today. Thank you.
Thank you.
So that's it. Thank you. Mr. Shefke, you done? Okay. We'll continue moving on. Mr. Blanchet-Jonca for 2.5 minutes, please.
Merci, Monsieur le Président. Je poursuis mes questions.
Thank you, Mr. Chair. I'll continue my questions for Ms. Kelly. Ms. Kelly, in the review committee for Paul Bernardo, there were 2 recommendations. Firstly, that CSC Canada share the conclusions of this review and share these things with victims before sharing them with the media or other members of the public, which you said you did. And secondly, was to strengthen victim notification and commitment to victims by creating a committee on this topic. And you said you did this. What I would like to know is, since you implemented these 2 recommendations, what has your organization done since these recommendations were shared? Well, like I said, we established the committee. We talked about how we share this information, when it is shared. Kirsten might be able to say more on this. Might be able to talk about the different steps and the measures that were implemented. So concerning this whole topic of Paul Bernardo's transfer, with the recommendations, you have stated that you're ready to implement them, but has anything been done differently? If we take a step back and we look at the situation today, what could have been done differently? So in terms of departmental directives, something that I think is good is that when there is a transfer that is being considered, we speak with victims, we inform them that it is being considered, and we ask if they would like to update their declaration and if they would like us to speak with them. I have had the opportunity of speaking with victims, and I think it is a good thing. What would you say on the topic of the Canadians' trust in our legal system and correctional services? What message would you like to send to Canadians today on the topic of these recommendations and things that could be improved in the future? I've spent a lot of time with correctional services, and so it's difficult to hear that Canadians don't trust our decisions anymore. As a commissioner, I do not want this to be the case. I would invite all members of the committee to come into our institutions and to see the work that we're doing. But what's for sure is that I'm very open to suggestions. I know there is work to be done in order to help victims.
Move on to Ms. Barron now for 2.5 minutes, please.
Thank you, Chair. Ms. Kelly, I can't remember, you said that you were 41 or 42 years, 40 years. In 40 years, I'm certain there's a wealth of information that you could provide to us, and I'm just curious if you can share in those 40 years if you've seen any patterns or changes in security cases being overridden and moved to lower security. Have you seen any patterns of that increasing recently? Any thoughts on that?
No, actually, obviously, when I started, there was you had to write your reports. There was no computers. There was no social media. But in terms of at the core, I was a parole officer. That's how I started, and we did the same thing. It was, we assessed areas. We transferred inmates to minimum. Actually, I will say, though, early on in the 1980s, there were a lot more escapes from minimum, for example, and I think it's been mentioned. We don't have as many. The population has changed, though, a lot since I first started with CSC. There's a lot more complexities in the inmate population.
Thank you.
And I just want to say, because our staff do phenomenal work in very, very challenging circumstances. And I just want to thank them.
Thank you. Very appropriate. The question that was posed by one of my Conservative colleagues around sharing the constituent who's asking the question around, if not Paul Bernardo and maximum security, then who, really resonated with me, because I hear us talking about the differences of the experience that Paul Bernardo would have in a maximum security versus a minimum, medium security. I almost did that again. I apologize. So then why do we have maximum security? If there's really no difference of experience, I'm not understanding. Maximum security seems like the place for somebody like Paul Bernardo, who's showing no remorse. He's a risk to the public. He's a risk to other inmates. Why is he not in maximum security? And if not, to reiterate the question of my Conservative colleague, who is in maximum security?
So the people who are in 5 seconds? Okay, so very quickly are the people that their behavior we cannot manage elsewhere. So they assault staff. They throw urine on staff. They stab each other. These.
Sorry.
Pardon me?
Thank you. Thank you.
Oh, okay.
Time's up. Yes, we'll move on to Mrs. Thomas, please.
Thank you. Ms. Kelly, you opened up your remarks by saying, and I quote, "Victim safety continue to be top of mind," end quote. Is that true?
Yes.
So in the case of Bernardo, victims were told only after the transfer took place, or maybe simultaneously. But nevertheless, Bernardo would have known before the victims knew. Does that sound like victims were put first?
Well, first of all, we work with the offenders. There's different reasons for a transfer. So definitely they're involved in the process. In terms of notifying victims, in this case, as I said, we notified them the morning of. Normally, for medium security, according to legislation, we notify them after the transfer. But in this case, because of the high-profile nature of the case, we notified them of them in the morning. However, with the multidisciplinary committee that we've established, these are things that we are discussing and seeing how we can enhance information to victims.
Okay. I find it interesting because you continuously go back to the findings of the multidisciplinary committee, and yet at the same time, you seem to be quite defensive of this terminology around achieving balance. Balance in this case, according to the Supreme Court decision in 2012, the language used around that, and I'll quote, is this, that there would be a just and proportionate balance based on the particular case before the court. Just and proportionate. Proportionality suggests that the scale isn't like this, but rather that the factors are considered that might tip the scale slightly. That's balance, according to the Supreme Court decision in 2012. In this case, that scale was tipped towards Bernardo and not towards the victims' families. Why is that?
Again, in this case, we did the security classification, we did the transfer, and as per legislation, we notified the victims the morning of. But moving forward, and this is what I was saying in French, now when we consider a transfer, when we're going to support a transfer, we will reach out to the victims so they have a chance to update their victim statement. So I think that's a good thing. And we're very open to that.
Okay, so again, though, Mr. Bernardo was put ahead of the victims. Why?
I wouldn't say he was put ahead of the victim. Again, we
would say that notifying the victims after the transfer or simultaneously was putting them at a fair place?
Well, first of all, we would have considered as well in the transfer decision any victim statement that they had provided. So that would have been part, definitely, of the...
Just to be clear here then, Ms. Kelly, you're saying that you considered their statement, and based on their statement, you determined that it was in their best interest to find out either simultaneously or after the transfer took place. You decided that based on the victim's statements, that's what would be in their best interest.
No, it's two things. If the victims actually submit a victim statement, an updated one, that's considered in the transfer process. In terms of the notification, once it was decided that he was going to be transferred, again, we followed the law and the policies.
Ms.
However,
Kelly,
moving forward...
I understand moving forward what your intentions are. I hope that's true. But what I've heard over and over and over again from you here
today...
Point
of order, Mr. Chair. Point of order. Mr. Chair, I believe my colleague is badgering the witness. I suggest that's not appropriate.
Thank you. Thank you, Mr. McKinnon. Continue. Ms. Thomas, please.
Thank you. Nevertheless, what I hear today is that in this case, Bernardo was put ahead of the victims. I'll give the remainder of my time to Mr. Tony Baldinelli.
You have 30 seconds, Baldinelli.
Quickly, just building on my colleague's comments, Benjamin Roebuck, the federal ombudsman, stated this on the transfer and its decision. He indicated that the system strikes the wrong balance between victims' rights and prisoners' privacy rights. The entire, indicating, the system is imbalanced, leading to the question, who does the justice system serve?
Well, for us, obviously, we have the protection of, we take into consideration the protection of the public, of our staff, our institutions, And we also work with victims and provide them information. And we have 8,000 registered victims. And that amounts to approximately 40,000 contacts per year.
Thank you. Time's up. And we're going to move to Ms. O'Connell now.
Thank you, Mr. Chair, and thank you again for answering all these questions. I think it's been very helpful. I want to follow up on Ms. Barron's last question where you were kind of cut off, because at the beginning of the testimony, we talked about how maximum versus medium is not an extension of the sentence that any given offender is provided. And you started to explain, and I don't think it's necessarily a mistrust by Canadians, it's a not understanding of the interworkings of correction services. So you were talking about the types of inmates that would be in maximum. Can you continue with that answer, because I found it very helpful?
So very quickly, over 95% of the inmates in maximum security are inmates that we cannot control their behavior other than in that environment. Like I said, they assault staff, they assault other inmates, they traffic drugs. So they need a high degree of control and supervision. Paul Bernardo is not that type. Again, I know he committed horrific crimes. He's certainly, now he's at minimum, but there are offenders that never get to minimum, medium, but there are offenders that never get to minimum security.
And so thank you for that, because I think it's a crucial point that the suggestion that, that meddling in this classification process could actually leave our correctional services employees at risk. And that the process is, again, not a determination of sentence, but a safety issue primarily for the people who serve Canadians to actually do this incredibly difficult work, with people who have committed the most heinous of heinous crimes. But we have people that work in those institutions, and ensuring that the right classifications and security measures are amongst those who serve the greatest risk, and to ensure that those parameters are put in place to keep our essentially employees at safe and protected doing this work. Is that a fundamental piece of the maximum versus medium?
Absolutely. It's very, very challenging environment, but as I said, maximum security are institutions for those that their behavior cannot be controlled elsewhere.
Thank you. And the incentive to even move to medium, for example, where the perimeters are still secure, to keep that public safety risk or lack of risk there, but the incentives for good behavior would also encourage inmates to not then go and attack correctional service workers, and that they still would have controlled limits to ensure that there's not a chance of escaping, or that there's not somehow a more comfortable stay in prison, but as a mechanism for behavioral changes to ensure the safety of correctional workers.
Absolutely. And we work with the offenders through programs, interventions, and services. And the goal is always so that they can acquire certain skills and move to, let's say, medium, because a lot of inmates in maximum security are serving determinate sentences and are going to be released. And we want to ensure that when they are released, they are better than when they came in, and ensuring the safety of the public.
Thank you, and I think that's certainly the case, and we could probably have an entire conversation on determinate sentences and inmates. But in this case, where it's indeterminate, one would think, there who cares if he is someone that can never be rehabilitated? There's no benefit. But if the benefit is to ensure a behavior that keeps correctional workers safe, then there is a benefit.
Absolutely.
To ensure that behavior doesn't invoke more violence within the system and more violence to innocent victims who are those who, frankly, do incredibly difficult work on behalf of Canadians to keep those inmates secure and not a risk to public safety. Thank you.
And thank you, Ms. Kelly, for your cooperation and all your answers, and everyone else sitting at that end of the table. We appreciate it. So at the moment, that brings this meeting to an end. So I will look to agreement to adjourn the meeting. Meeting's adjourned.